Okay, let's unpack this. The ever-evolving world of sports law.
It really is.
It's a field that's constantly shifting, and what we've got today is a stack of insights that are fresh off the presses from the Sports Litigation Alert.
Yeah, some really interesting stuff coming out.
We're going to cut through the noise and give you a real shortcut to understanding the latest and most intriguing legal issues shaking up the sports world.
What's fascinating here is just how quickly things are changing. I mean, it's impacting everyone.
From high school athletes.
Yeah, making crucial decisions about their futures all the way up to major professional leagues navigating these massive financial and regulatory landscapes.
Right.
This isn't just about, the wins and losses on the field or the incredible athleticism we see. It's really about the complex legal battles happening behind the scenes, and those are truly shaping the future of competition and entertainment as we know it.
Our mission today is to arm you with key knowledge, whether you're a law student eyeing this dynamic field.
Which is a growing field, definitely.
Yeah, absolutely. Or an attorney already working in sports. Or maybe just a super fan with that insatiable legal nerd streak.
We see you out there.
We've pulled together a fantastic mix of recent cases, some in-depth articles revealing interviews, all custom-tailored to highlight the essential legal developments.
The challenges, too.
Right, the challenges and the shifting paradigms that are defining this incredibly dynamic area of practice.
Yeah.
You're definitely in for some real aha moments.
We'll be connecting a lot of dots for you today, exploring not just what happened in these cases.
This is important,
but digging into why it matters. What are the broader implications for everyone involved in sports, from the collegiate athlete trying to navigate new rules.
Like NIL.
Exactly. All the way to the global professional leagues grappling with billions of dollars in international regulations. It's a huge scope.
Okay, first up, let's dive into what feels like the Wild West of collegiate athletics right now.
That's a good way to put it. Wild West.
It seems like every single week there's a new headline about name, image, and likeness, NIL, or the transfer portal.
Constant churn.
It's not just creating a new legal playing field, it's a rapidly expanding, often chaotic legal frontier, rife with unprecedented challenges for athletes and institutions alike.
Absolutely. And one of the most significant, certainly financially impactful developments looming is that proposed $2.8 billion settlement of House v. NCAA.
Huge number.
Massive. And on its face, it looks like this big resolution that could bring some stability, right?
I hope so.
But it's actually generated considerable controversy. It's revealing these deeper fault lines within the NCAA structure itself.
How so?
Well, we're already seeing smaller Division I schools, particularly those outside the Power Four conferences. Think schools in places like South Dakota. They're initiating lawsuits. Their core claim is that they're being overcharged by this settlement. They argue it places this undue financial burden on schools that just don't have the colossal revenue streams of, say, the Big Ten or the SEC.
Right, they can't absorb that hit the same way.
Exactly.
And it gets even more complicated when you look at Judge Wilkins' concerns. She's highlighted a really significant issue buried within the settlement proposal.
The roster caps.
Yes, the shift from scholarship limits to roster caps. The NCAA wants to abruptly apply these caps, apparently, rather than phase them in gradually.
Yeah, that's the plan. And it's expected to disproportionately affect non-revenue sports. Think track, swimming.
Walk-ons, too.
Walk-on student athletes, absolutely, and those on partial scholarships. It sounds like a change that could have really far-reaching, maybe unintended consequences beyond just the big-name players.
Okay, explain that unintended consequence piece. What's the fear there?
Precisely. The true insight here is that this settlement, while it seems to resolve one antitrust issue, the argument that amateurism rules unlawfully restricted compensation.
Right, the core of House.
Yeah. It's inadvertently creating this financial incentive to actually shrink college sports opportunities for the vast majority of athletes not in football or basketball.
So it helps some, but potentially hurts many others.
That's the concern. This change isn't about opening up new financial opportunities broadly. It's fundamentally about reallocating and concentrating existing money within NCAA programs.
Okay.
Think about it. If a team is limited by total roster spots instead of scholarships, and the financial payout to revenue-generating athletes goes up.
Which it likely will under the settlement.
Right. Schools will inevitably have to reduce expenditures elsewhere to balance their budgets.
Makes sense financially.
Which could eliminate thousands of roster spots across Division I. fundamentally changing opportunities for many student athletes, particularly in sports like track and field, swimming, lacrosse.
Okay.
The ones that don't bring in the big TV money.
So Judge Wilkin is flagging this.
She is. Through a written decision back in April 2025, she actually gave the parties an admonition. That's a formal warning from the court.
Okay.
Giving them a final chance to address this specific issue, the roster cap problem or risk denial of the entire settlement.
Wow. So the whole $2.8 billion deal could collapse over this.
It's a critical moment for the future structure of collegiate sports participation. It puts immense pressure on the NCAA and the plaintiffs to figure this out.
So it's not just some technical legal point. It's a potential earthquake for athletic departments nationwide.
Absolutely.
And then shifting slightly, there's the whole enforcement side of NIL, which is raising a ton of questions.
Oh, yeah, the practicalities.
We saw the high-profile case of former University of Tennessee quarterback Nico Iamaleava. Highly rated recruit.
Big name.
Enters the transfer portal for UCLA. Reports suggested his frustration stemmed from his NIL deal and maybe some growing tension with the Tennessee coaching staff and their collective.
Right.
This raises a huge, very practical question for schools and their legal teams.
Mm-hmm.
What real power do schools have to hold athletes to these complex NIL agreements?
That's the crux of it.
What are the legal uncertainties around these contracts, especially when an athlete feels, an agreement isn't meeting expectations or they just decide they want to move on? It's a real quagmire.
It's an incredibly challenging area because these aren't traditional employment contracts like a pro athlete's deal.
Not yet, anyway.
Not yet, exactly. But they carry significant financial weight and unique considerations. The legal frameworks governing NIL are still developing, leaving so much uncertainty.
Like what, specifically?
For instance, what happens if an athlete fails to perform the promotional duties outlined in their NIL agreement? Or if a collective promises certain compensation that just never materializes?
Happens all the time, probably.
The recourse mechanisms are largely untested in court. The ability of schools to enforce these agreements or for athletes to seek damages is still a very gray area. And when you factor in NIL collectives, the situation becomes even murkier.
Okay, so with the collectives?
Well, these high-dollar NIL deals, like Utah's Crimson Collective, reportedly gifting, $61,000 trucks to football players?
Yeah, I remember that. Pretty splashy.
That directly challenges the exclusively charitable standard for 501c organizations.
That's fascinating. So a collective's tax-exempt status, meaning they don't pay federal income tax.
Right.
That hinges on them not directly compensating individuals in a way that provides a private benefit beyond a charitable purpose.
Correct.
But if you're giving away luxury vehicles, it's pretty hard to argue that's merely incidental to charity, isn't it?
Seems like a clear conflict with IRS guidelines, yes.
How diligently are these incidental benefits actually being scrutinized by the IRS? Are we seeing big enforcement actions against collectives, or is this still kind of a gray area they're exploiting?
That's a crucial question. Treasury regulations do allow some incidental private benefit if it's both qualitatively necessary and quantitatively insubstantial.
Okay, there's wiggle room.
But these high-dollar NIL deals seem to cross that line pretty obviously. The IRS has put out some general guidance.
What does it say?
Indicating that if a collective's primary purpose is just arranging NIL deals for specific athletes, it likely doesn't qualify as a 501c3. However, direct enforcement actions, they've been slow, which suggests it remains an evolving area of tax law.
Interesting. So some are trying to thread the needle.
Some collectives, like Jackets for Philanthropy, they attempt to blend charity work with athlete compensation, like requiring athletes to participate in community events in exchange for NIL funds.
Trying to justify the charitable link.
Exactly.
Yeah.
But they often struggle to meet the strict, exclusively charitable tax law standards because the substantial private benefit to the athletes tends to overshadow the charitable intent.
Gotcha.
This is in stark contrast to the NCAA itself, which has maintained its tax-exempt status for decades. Why? Because its relationship with student compensation is indirect.
Like coach salaries.
Coach salaries, for example, are school-based, paid by the university, not directly by the NCAA. It's a key distinction.
Okay.
And just to briefly touch on it, there are also unique NIL considerations for international student athletes.
Oh, yeah, visas and things.
Visa implications, amateurism rules of international sports federations they might still be subject to, foreign income tax obligations. It adds another layer of complexity for legal professionals advising them.
Definitely. Okay, so it's not just NIL creating headaches.
Yeah.
The transfer portal itself.
Yeah.
Massive growing pains.
Huge.
And it's not just at the collegiate level anymore. We saw the Lenoir Ryan women's basketball case, for instance.
Right.
Plaintiffs claimed they were forced off the team, while the coaches attested the players actually planned to enter the transfer portal anyway.
A classic he said, she said.
It really highlights the differing perspectives on athlete departures. Is it choice or is it coercion? And this dispute underscores the importance of clear communication and, frankly, well-drafted legal parameters around team dynamics.
Absolutely. It can easily escalate into a full-blown legal battle if not managed carefully.
And these cases, they often turn on specific facts, right? Communications between coaches and athletes.
Exactly. It makes proving intent really challenging. And this whole player mobility thing is starting to affect high school sports, too. That's a new frontier for this kind of legal complexity.
Also, legislation.
We're seeing legislative efforts like Gervin Hawkins' third attempt in Texas to file a bill allowing high school athletes a one-time transfer without sitting out a year.
Okay, what's the pushback?
The opposition naturally raises concerns about increased recruiting at the high school level. They fear it'll disrupt team cohesion, academic focus.
The usual arguments.
Right. But Gervin Hawkins counters that recruiting already happens, even though it's technically banned and often goes unreported.
Good point. It's already the reality.
This bill represents a recognition of that reality, seeking to legalize a practice that is already widespread and maybe bring more transparency to it.
Interesting. Okay, let's unpack this further. Beyond NIL and transfers, there's this consistent drumbeat of antitrust challenges hitting the NCAA. And it's fundamentally reshaping how they operate. The sentiment out there, voiced by legal experts, is incredibly clear. There is no NCAA bylaw or rule insulated from antitrust challenge.
That's a profound statement, and it's absolutely right.
That's a core legal principle putting existential pressure on the NCAA's traditional amateurism model.
It really is. The NCAA's traditional defense of its rules, it's basically crumbled under the weight of antitrust scrutiny. We saw this play out vividly in Pavia v. NCAA.
What happened there?
A court actually issued a court order specifically prohibiting the enforcement of specific NCAA bylaws, 12.02.6 and 12.8.
What did those bylaws do?
They were designed to protect the amateur model by restricting how and when athletes could transfer, especially from junior colleges, JUCOs. They imposed waiting periods, limited opportunities if you'd previously competed at a four-year school.
Okay.
The court ruled these restrictions were anti-competitive under the Sherman Antitrust Act, basically an unreasonable restraint of trade.
And the NCAA's response?
Telling. They issued a blanket waiver for affected JUCO athletes from the 2024-25 academic year, granting them an additional year of Division I eligibility for the 2025-26 season.
So they folded pretty quickly on that.
It shows the direct, immediate impact these antitrust challenges have on player eligibility and careers.
And there's another ongoing case, Arboleda v. NCAA.
Yes, a waiver request is pending there for a JUCO athlete who claims potential NIL compensation of at least $50,000 was lost due to the rules.
So it reinforces the economic implications. It's not just about playing time, it's about money being denied.
What's crucial here is that courts are increasingly focusing on whether NCAA rules unfairly restrain trade in the college athlete labor market.
That term labor market is key.
Historically, the NCAA defended its rules under the premise of maintaining amateurism, arguing it was essential to the unique nature of college sports.
Yeah, the student-athlete ideal.
But that defense has been largely rejected by the courts now, as one expert noted quite pointedly.
What will they say?
To the extent that the amateurism principle has been declared dead, this court has buried it.
Wow. Okay, no mincing words there.
This fundamental shift in judicial perspective means the courts are now viewing college athletes much more like workers in a labor market.
Right.
And NCAA rules are seen as potential restrictions on that market. That has profound implications for how the NCAA will function, or even if it can continue in its current form.
And this leads directly into the shifting sands of student-athlete labor status. Big development recently, right?
Huge. Acting General Counsel William Cowan of the NLRB, the National Labor Relations Board, he rescinded GC Memo 2108. That memo previously addressed the statutory rights of players at academic institutions, student-athletes, under the National Labor Relations Act.
And what did that memo argue?
It was issued by a previous general counsel, Jennifer Abruzzo, and it had asserted that certain college athletes could be considered employees with the right to unionize and collectively bargain.
So rescinding it is a big step back from that position.
A huge move, yes. But this reversal didn't happen in a vacuum.
Lobby.
Intense, systematic lobbying efforts by the NCAA, the conferences, universities themselves, all pushing hard for federal legislation.
What kind of legislation?
Something that would explicitly preclude student athletes from being classified as employees of their schools.
Why do they want that so badly?
They argue that employee classification would fundamentally alter college sports, lead to massive financial burdens, potentially end many non-revenue sports.
The classic arguments.
Exactly. We actually saw a bill trying to codify that non-employee status pass a House committee in June 2024.
Did it become law?
No, it ultimately failed to advance to the floor for a vote. Shows just how divided Congress is on this.
So it's still very much up in the air.
This ongoing tension between federal labor law, powerful lobbying, potential future court rulings, it's a complex legal dance, and the stakes for the NCAA's future are enormous.
It's clear the lines between amateurism and professionalism are blurring incredibly fast in college sports. It's creating a legal landscape that's almost unrecognizable compared to just, say, a decade ago.
Totally different world.
But the legal challenges aren't just about money, right? They're also deeply personal, touching on identity, equity, safety.
Absolutely.
And here's where it gets really interesting, particularly concerning Title IXs. It's just a hot-button issue, huge societal implications, and the legal battles are truly illuminating.
Indeed. We're seeing significant Title IX and gender equity claims emerge that challenge established practices. Take the University of Oregon case.
What happened there?
Women athletes' claims of sex discrimination under Title IX were allowed to proceed. The court let the lawsuit continue.
Even though Oregon had that big Women in Flight fundraiser, raised millions.
Yeah, despite that success, which raised over $15 million, suggests that fundraising alone isn't enough to satisfy Title IX's obligations.
So what was their argument?
The plaintiffs argued that unequal treatment allegations are based on a pattern of conduct that pervades or pervaded their time as a student athlete.
Ah, the pattern argument.
Yeah.
Affects the statute of limitations.
Exactly, arguing the discrimination was ongoing, and they specifically alleged they received less NIL-related training opportunities and income compared to male athletes.
So NIL is becoming part of Title IX claims now, too.
It highlights how new areas like NIL are becoming grounds for Title IX claims. It's not just about facilities or scholarships anymore.
So it's not just what they were explicitly denied, but this broader pattern of harm affecting opportunities, including in the emerging NIL space. That's a significant expansion.
It is.
And then you have retaliation claims like the Brian Saylor v. Emporia State University case.
The former women's soccer coach.
He sued for gender equity complaints under Title IX, alleged retaliation for using his First Amendment rights, his free speech. After being fired following an alcohol incident involving players, it raises the question, was the firing due to a legitimate breach of conduct, or was it because he spoke up about inequities? Blurs the lines between legitimate action and punitive retaliation.
It's a classic example of how these cases often have multiple layers. Alleged wrongdoing requiring careful disentanglement in court.
And beyond that, cover-up claims are surfacing, highlighting university due diligence and transparency issues.
Yes. In the Barrio v. University of Maryland Baltimore County case, a new athletic director alleged fraudulent inducement, retaliation, and libel.
What was the claim?
He claimed UMBC administrators misrepresented that prior sexual misconduct and gender equity complaints had been fully resolved when, in fact, they hadn't been.
Oof, it's serious.
It underscores the need for transparency and thoroughness in university investigations. Misrepresenting the status of sensitive issues can lead to severe legal consequences for the institution and its leaders.
And speaking of investigations, there was a recent ruling with broad implications for a university's duty to investigate.
Tell me about it.
The court stated that a report containing sexual grooming allegations may suffice to trigger a university's duty to investigate under Title IX, even if based only on suspected conduct.
Okay, so not proven, just suspected.
Right. This decision might make it easier for plaintiffs to survive an initial motion to dismiss under Rule 12b-6.
Which is the motion to dismiss for failure to state a claim.
Exactly. It reinforces that institutions have a proactive obligation to investigate, rather than waiting for more detailed factual allegations to surface.
This is a significant development. It lowers the bar for initial complaints to proceed, putting more pressure on universities to take early allegations seriously and act swiftly.
Definitely.
Now, moving to an even more contentious and frankly politically charged area, the transgender athlete debate.
Oh boy.
Reveals a truly divided legal landscape across states at the federal level. It's a complex intersection of civil rights, biology, evolving societal norms.
You can see the conflict just by looking at state laws. California's AB 1266, for example,
allows participation based on gender identity.
Right. Allows transgender women to compete in women's sports based on gender identity. It's criticized by groups like Advocates for Faith and Freedom, who argue it conflicts with federal Title IX protections.
What's their argument?
They assert it undermines female athletes, forcing them to compete against biological males who hold undeniable physical advantages, fundamentally changing women's sports.
Okay.
We even saw the case of TS, a student removed from her cross-country team in order to cover Save Girls sports shirts that were labeled hostile. Shows the intense social and emotional dimensions here.
And in stark contrast, you have Florida's SB 128.
Which does the opposite.
Relies on biological sex classifications at birth to, quote, protect fairness and opportunities in women's athletics. It was found valid by a district court under rational basis review.
Explain rational basis review again.
It's the lowest bar for a law to clear in court. The government just needs to show a legitimate state interest for the law, and that the law is rationally related to achieving that interest.
So the court bought the fairness argument.
In this case, the court accepted that protecting fairness and opportunities in women's athletics by relying on biological sex was a legitimate governmental goal, and the law was a reasonable way to pursue it.
So you have these totally conflicting state approaches.
Demonstrates the deep legal and philosophical divides. Leads to a patchwork of regulations nationwide. Very confusing for athletes and schools.
And the federal government is getting involved in a big way now, right? Adding another layer.
Yes. The U.S. Department of Education, ED, and Department of Justice, DOJ, recently announced the creation of a Title IX Special Investigations Team, or SIT.
What's its purpose?
Its stated purpose: to ensure timely, consistent resolutions to protect students and especially female athletes from the pernicious effects of gender ideology in school programs.
That language seems pretty pointed.
It's a significant move by the federal government to assert its stance. U.S. Secretary of Education Linda McMahon explicitly explained the reason for SIT's creation.
What does she cite?
Citing a staggering number of complaints about men competing in women's sports and invading women-only intimate spaces, signals a clear shift in federal enforcement priorities.
Are they taking action?
The Office for Civil Rights, OCR, part of ED, has taken specific, highly publicized actions. They found Maine in violation of Title IX for allowing 2 transgender girls to participate in youth facilities, gave the state a strict 10-day deadline for changes.
Wow, 10 days.
They also moved to suspend $175 million in federal grant funding to the University of Pennsylvania for allowing Leah Thomas, a transgender woman, on its swim team, citing a 2025 Trump executive order.
Suspending funding is a huge hammer.
Absolutely. And furthermore, a complaint was even filed against Delaware's policy, despite there being no known transgender athletes participating under that policy in the state.
So they're being very proactive.
Shows a very proactive and assertive enforcement stance. Suggests a broader agenda beyond just individual cases.
Okay, shifting from identity and equity. Athlete safety and welfare. Always a critical legal frontier. And just a core duty for any institution.
Absolutely fundamental. The duty of care in collegiate sports is paramount.
Take the tragic Dickey v. Bucknell case.
Rhabdomyolysis, right?
Yes, involving the robbed to death of a freshman offensive lineman. Bucknell was aware of his sickle cell trait, a known risk factor for rhabdo in athletes.
And NCAA guidelines specifically require caution, modified training for athletes with this condition.
Right. And disturbingly, there was another rhabdo incident with the same coach within the program.
That points to potential systemic issues, doesn't it? Whether proper protocols were consistently followed.
Exactly. Similarly, the NRV Trinity High School case. Heat stroke.
Awful.
Student-athlete found unresponsive, dangerously high, 107.5-degree air core temperature, suffered significant organ damage.
And the allegations weren't just about that one incident.
No, the lawsuit includes a broader pattern of alleged coach misconduct, institutional failures in supervision, training, timely medical intervention, even though they had equipment like cooling tubs available.
These cases just underscore the severe legal liabilities institutions face when player safety is compromised, the immense importance of adhering to medical guidelines, proper protocols, adequate supervision.
It's basic stuff, but clearly sometimes overlooked.
Critically important.
And it's not just about on-field incidents either. Concussion safety research keeps evolving.
Constantly challenging assumptions about protective gear.
Right. A recent study on football helmet covers, like Guardian caps, found they do not reduce concussions for high school players.
That's surprising, isn't it? Counterintuitive?
Yeah, you'd think extra padding helps. What's also surprising, though maybe needs more research, is a preliminary finding.
What's that?
Nearly an 8-fold higher level of sports-related concussions during practices among female football players than male.
Wow. But you said preliminary. Small sample size.
Critically important caveat, yes. Based on a small female sample size, definitely needs more research, but raises questions.
And from a legal standpoint, proving negligence caused the injury. That proximate causation piece can be incredibly challenging.
Right. Talk about the Walton B. Premier case.
In that case, a negligence claim failed because the failure to distribute concussion rules wasn't found to be the proximate cause of the daughter's injuries.
Why not? They failed to give out the rules. That seems negligent.
The court reasoned there was no evidence the family would have acted differently, like pulling her from the sport or seeking different medical advice, even if they had received the information.
Ah, so you have to show the negligence led to the harm.
Exactly. It highlights the strict legal burden of proof. That's the challenge of proximate causation. Even if someone was clearly negligent, the plaintiff still has the burden to show a direct, unbroken chain. The negligence directly caused the injury, and it wouldn't have happened otherwise.
It's a high bar, often more complex than just proving someone made a mistake. So what does this all mean for oversight bodies, like the U.S. Center for Safe Sport?
It was established to protect young victims from abuse in sports, but its reach is now being challenged.
How so? Jurisdictional overreach.
Yes, Mr. Strine, in a significant legal challenge, has claimed that Safe Sport exceeded its jurisdiction under the Protecting Young Victims from Sexual Abuse and Safe Sport Authorization Act of 2017.
What's the argument?
He argues Safe Sport exercised authority over conduct that in no way involved sport and where no sport-related relationship existed between the parties, meaning the alleged abuse didn't happen within a sports context or involve people connected through sports activities.
So challenging the scope of their authority.
It's a critical legal challenge. Questions the very boundaries of Safe Sport's mandate, potentially limiting its ability to investigate certain claims impacting victim protection efforts.
And beyond specific incidents and oversight bodies, broader sport-related mistreatment. It's a pervasive societal issue, getting quantified now.
Alarming statistics, yeah. A study from Ohio State University using the National Sports and Society Survey found nearly 40% of adult Americans say they've experienced some type of sport-related mistreatment in their lives.
40%, that's massive. Includes name-calling, bullying, discrimination, abuse.
It's a huge portion of the population, and the study revealed crucial insights into who is most vulnerable and where it happens.
Who is most vulnerable?
Mistreatment is more common for males, sexual minorities, individuals with health problems or disabilities, those with weight-related stigma, and less popular or less athletic kids.
And where does it happen most?
While it occurs across settings, rec leagues, elite programs, it's notably more frequent in elite and competitive environments.
Makes sense. Higher pressure.
And the study emphasized these experiences are generally not isolated and simplistic events, implying they're often part of a broader systemic issue. Highlights how pervasive mistreatment can be within sports culture, requiring more than just individual interventions.
The well-being and equitable treatment of athletes. Clearly a monumental legal challenge, evolving far beyond what we traditionally thought of as sports law.
Definitely.
Now, let's pivot to the equally high-stakes world of professional sports. Big money, complex legal battles colliding in the public eye.
Where it gets really interesting.
Yeah, the money, the moves, the intellectual property battles shaping the pro sports world. These aren't just local stories, massive implications for entire leagues and cities.
Absolutely. Stadium development and financing. High-stakes games for any legal team involved, billions of dollars, significant public investment.
We're seeing this play out with team relocation and complex state laws.
Yeah.
You mentioned the Oakley v. MSG war earlier.
Yeah, continues to be a fascinating example of high-stakes litigation, though maybe more on the IP side. But then there's the Cleveland Browns' ongoing legal battle against Cleveland City over the model law.
Right. The Browns are arguing the model law, which requires a team give 6 months' notice before relocating if it got public funds. They say it's unconstitutional.
On what grounds?
Violates the Commerce Clause, regulating interstate commerce, the Contract Clause, Privileges and Immunities Clause, void for vagueness, a full constitutional assault.
And alternatively,
they claim it doesn't even apply because their lease expires before a potential move, making the law moot for them anyway.
And the city's counter.
That the 6-month delay required by the law is perfectly reasonable, especially given the substantial public investment in the team's facilities over the years.
Makes sense. The broader implications here are significant for the whole NFL. State interventions like the model law risk colliding with the Commerce Clause.
Because teams are part of a national business.
Exactly. NFL teams are viewed as an integral part of a complex, interwoven national business apparatus. Past cases like City of Oakland v. Oakland Raiders reinforce that such regulation, if needed, should probably come from Congress to assess the impact on interstate commerce.
Not individual states creating a patchwork.
Right, that could create chaos. Especially because franchise relocations like the Rams to Inglewood, the 49ers to Levi's Stadium have demonstrably generated substantial economic benefits for their new locations, involving out-of-state fans, sponsorships, national broadcasts, all clearly implicating interstate commerce. That falls under federal regulatory purview.
And it's not just relocation, it's public funding for these massive projects. The statistics are striking.
What are they?
Only 14 out of the 124 teams in the NBA, NFL, MLB, and NHL are fully privately funded.
Only 14?
With 5 of those even being in Canada. So the vast majority rely on some form of public subsidy in the U.S.
Wow. That highlights the ongoing debate, the complex dance between public and private interests.
Local governments argue it boosts the economy. Jobs, tourism, tax dollars.
Right, the justification. But teams frequently leverage the threat of moving to secure that funding, effectively holding cities hostage sometimes.
A delicate negotiation puts legal teams under immense pressure to protect public and team interests simultaneously, battling tight deadlines, intense public scrutiny.
For sure.
We've seen a couple of interesting case studies recently putting this in perspective. The NYCFC Stadium project. Lengthy and painful negotiations with the NYC Economic Development Commission over the land lease. Why so painful?
Well, typically these negotiations drag on because you have so many stakeholders, complex land use regulations, environmental reviews, community benefits agreements, and of course the money, the financial terms of the lease itself.
Where do they usually get stuck?
Sticking points often revolve around who bears the risk of cost overruns, the lease duration, the extent of community access and engagement.
Okay.
But in the NYCFC case, the club showed a significant commitment to local and union labor. MWBE targets minority and women-owned business enterprise goals, and designing the venue as a year-round community resource, not just a game day facility.
So being proactive helped.
That proactive approach to community integration can often smooth over some of the legal and political hurdles, build goodwill.
And the Tennessee Titans' new stadium project,
Yeah.
a strategic pivot, right?
Yeah, they initially planned a massive renovation of their existing stadium, but extensive due diligence structural infrastructure assessments revealed underlying issues.
Made renovation too expensive.
Made renovation costs comparable to a new build. It shifted from a major facelift to essentially starting from scratch.
Which requires a whole new approval process.
Exactly. Necessitated a massive team effort for approval, a challenging 14-month lobbying period to find a collaborative solution with city and state officials for financing land acquisition.
Lots of legal and political maneuvering.
A testament to how legal teams, alongside business and government relations, have to adapt quickly to new info and build consensus. We heard from outside counsel Lisa Glan.
What was her advice?
That in these initial stages, keeping the decision-making group small and focused, legal, ownership, risk advisors, key community leaders, is absolutely crucial.
Laying a solid foundation.
This core group lays a solid foundation for all subsequent legal and business decisions, helps identify and mitigate complex construction and financing risks early on before they escalate.
Smart. Okay, switching gears to antitrust and competition within professional leagues. Clearly not just a collegiate issue.
Not at all.
Pro tennis governance is under intense scrutiny. A class action lawsuit by a dozen pro players and the PTPA Professional Tennis Players Association.
Right.
Against the 4 leading tennis governing bodies. What's the core allegation?
A conspiracy by a cartel of tour organizers and tournament operators to avoid competition and control players' pay and working conditions.
A cartel. Strong language.
They claim this creates a rigged game where players have limited power over careers and earnings due to collective control over prize money, scheduling, endorsements.
So basically alleging price fixing and market allocation.
It's a bold antitrust claim. And the immediate acrimonious exchange of letters between legal teams regarding alleged intimidation of the players involved.
Trying to silence them.
That's the accusation. It signals just how high the stakes are, not just financially, but for future player power and governance structures in tennis.
And over in NASCAR, a really interesting charter dispute.
Yeah, the teams versus NASCAR.
23XI and FRM2 race teams suing, challenging NASCAR's 2016 and 2025 charter agreements as anti-competitive, seeking an injunction damages.
And these charters are valuable, right? Guarantee spots, revenue share.
Incredibly valuable. But what's particularly interesting is NASCAR's counterclaim.
What are they alleging?
Accusing the teams of a per se illegal cartel under the Sherman Act. Okay, explain per se illegal again.
It means the conduct is so inherently anti-competitive, it's illegal regardless of whether it actually harms competition. No need to prove specific anti-competitive effects.
So what's NASCAR saying the teams did?
They're arguing these teams are leveraging collective bargaining tactics to demand better terms for themselves, which NASCAR characterizes as an illegal group boycott or price fixing.
So both sides are accusing the other of antitrust violations.
It's a classic antitrust battle. Each side claiming the other is engaging in anti-competitive behavior, trying to use the law to gain leverage in a high-stakes business negotiation.
Fascinating. Now, MLB, they have their own unique antitrust exemption. Historical anomaly, right?
Totally unique in American sports law. Stems from the 1922 Federal Baseball Club decision. Supreme Court basically ruled baseball exhibitions weren't interstate commerce, so exempt from federal antitrust laws.
Which gave the league huge power over players for decades.
Significantly diminished players' leverage during labor negotiations, meant players couldn't sue the league for antitrust violations like their NFL or NBA counterparts could, especially regarding things like the reserve clause, which bound players to one team indefinitely.
Limited their bargaining power, kept wages down.
Led to incredibly restrictive contracts, lower wages compared to what they might have earned in a competitive market. Congress eventually recognized this disparity contributed to the ugly 1994-95 work stoppage.
Yeah, that was bad.
Caused so much public anger, economic disruption. So Congress passed the Curt Flood Act of 1998.
What did that do? Fully repeal the exemption?
Partially repealed it, but only for MLB players, giving them the right to sue the league for antitrust violations related to their employment.
Only for employment issues?
Yes. It explicitly left the exemption intact for other areas of baseball minor league operations, team relocation, franchise sales. Still raises questions about its full scope and whether it truly levels the playing field across all aspects of the sport.
Still a bit of a loophole there. Okay, intellectual property battles. Also front and center in pro sports. Protecting everything from logos to game data.
Huge value there.
The New Orleans Saints fleur-de-lis trademark. Great example. You'd think a state symbol would be tough to trademark, wouldn't you?
It is, under federal law, 15 U.S.C. Section 1052B. Generally makes state or municipal insignia unregisterable.
So how did the Saints do it?
They successfully registered a stylized version because it was deemed sufficiently transformed to avoid being a prohibited simulation.
Meaning their specific design was unique?
Right. The court determined that the Saints' specific design, while derived from a public symbol, was unique enough that consumers would associate that particular design specifically with the Saints football team. It functions as a distinctive source identifier for their brand, not just a generic state symbol.
It's a nuanced application of trademark law, emphasizes distinctiveness.
Definitely.
And in the digital age, music copyright infringement. Huge and growing issue.
Oh, yeah. Teams using music on social media without licenses.
Cobalt Music Publishing America, Inc., and others are suing 14 NBA teams for unauthorized use of copyrighted music in social media postings. Instagram, TikTok, X, YouTube, Facebook.
Everywhere.
Highlights the ongoing expensive battle over IP rights in digital marketing. Teams absolutely need to meticulously clear all content, especially music, before it goes live.
Absolutely. It's a costly oversight otherwise. And beyond music, trade secrets in sports analytics, becoming fiercely guarded assets, a new frontier in IP litigation.
We mentioned the Oakley v. MSG war earlier as an ongoing IP dispute. But more specific is the Knicks v. Raptors lawsuit.
Yes, significant case. The Knicks are alleging misappropriation of trade secrets by a former Knicks staff member who accessed sensitive materials before moving to the Raptors.
What kind of materials? Scouting reports, analytics?
Could be scouting reports, player analytics, strategic game plans, proprietary training methodologies, anything giving a competitive edge.
This has broader implications for the whole industry, doesn't it? Especially with the massive explosion of analytics and film study.
Totally. Data, including from wearables like Whoop, holds immense value. Teams are fiercely guarding against misappropriation of proprietary data to maintain that edge, treating it like valuable IP.
We even saw the Phillies lawsuit implicitly against Zulu's Teamworks, right? Alleging irreparable harm.
Right. Alleging loss of competitive advantage if they can't control how data analytics suites provided by vendors are used. Irreparable harm means harm money alone can't fix, often key for seeking an injunction.
So this case could set a precedent.
Could set a precedent for how data and analytical tools from third-party vendors are managed and protected across leagues. Emphasizes competitive advantage isn't just resources, but securing and controlling proprietary data and insights.
It's not just logos and data either. Fascinating concept of trademarking less common features, like stadium structures, traditions, even chants.
Teams are exploring this, yeah.
Okay.
Beyond the usual mascots and names, trying to further protect and monetize their brand identity.
The Minnesota Vikings SKOL chant, good example.
Great case study for strategic enforcement and community building. You might think having a monopoly over a cultural phrase could alienate fans.
Right. Seems risky.
But the Vikings navigated it by collaborating with local businesses, allowing them to use the chant in marketing under specific licenses.
So balancing IP protection with fan engagement.
Exactly. Building goodwill. And in branding, we also keep seeing trademark confusion claims, like FFWCT, LLCV, USA Football, Inc.
What was that about?
USA Football accused FFWCT of infringing its USA flag trademark, the core issue, likelihood of confusion between tackle and flag football branding.
Which the court said was for a jury.
Determined it was a question of fact for a jury.
Yeah.
Involves assessing similarity of marks, services, marketing channels, strength of the original mark, shows the fine line in distinguishing related sports properties.
Okay, moving to team operations. Security, always a major concern. Fan safety, protecting athletes.
Huge liability area.
One NFL team recently survived a legal test of adequate stadium security in a tragic fan violence case. Summary judgment granted due to absence of causation.
Reminds you of Romero v. Los Angeles Rams. Stated a bare claim that more security personnel could have prevented a criminal attack shows only abstract negligence.
Emphasizes the high bar for proving direct causation in these security liability cases. You have to show the lack of security directly led to the specific harm, not just that security was generally inadequate.
And security technology itself is facing scrutiny, highlights the importance of due diligence in selecting vendors.
The FTC case against Evolve Technologies.
Yes, the Federal Trade Commission accused Evolve of misleading claims about its scanner's ability to detect weapons and ignore harmless objects.
What were the examples?
Failing to detect a 7-inch knife, missing handguns in tests, even a 50% false alarm rate after sensitivity was increased.
Yikes, not good.
Highlights the legal risks when vendors' claims don't match real-world performance, potential consumer deception claims, and more critically, actual security vulnerabilities for venues.
Plus, new tech brings new challenges. Unauthorized drones.
Big problem. We saw federal felony charges against Alexis Perez Suarez for illegally flying a drone over M&T Bank Stadium during an NFL wildcard game.
Underscores the serious legal risks and public safety concerns of unauthorized drone use at major events. Significant disruption, potential threat.
Definitely. And beyond operations, a significant shift in pro-league ownership structures.
Private equity investment.
Exactly. Major American pro sports leagues have amended ownership rules to permit investment by private equity firms. Notable change, as traditionally ownership was limited to individuals or family groups.
But there are strict rules, right?
Yes. Designed to protect league integrity, requiring long-term investment horizons, limiting the number of teams a single firm can invest in, and crucially, limiting the control they can exercise over day-to-day team operations.
Why those limits?
Primarily to prevent the typical PE model take control, aggressively cut costs, quick resale for profit, from conflicting with the core goal of winning on the field and maintaining competitive balance.
So, ensuring profit pursuit doesn't undermine the sport itself.
It's about ensuring financial profit doesn't undermine the competitive integrity and long-term health of the franchise and the league. A fascinating balance between allowing new capital in and maintaining the essence of sports competition.
From the grand arenas and multi-million-dollar deals. Let's zoom in now on the individuals and specialized processes keeping the gears of sports law turning,
The nuts and bolts.
including the evolving career paths within this fascinating field. It's where legal theory meets very practical, often high-pressure applications.
A space where legal theory really gets put into practice every single day.
So what does this all mean for the legal minds actually navigating this dynamic world? Let's talk careers, evolving dispute resolution mechanisms. This is where you see theory put into practice.
Right.
One of the most talked about cases recently involved agent regulation and disputes. The Todd France arbitration.
Yeah, that was a rare and highly significant case within the NFL agent community.
What happened?
NFL player agent Todd France was ordered to pay over $800,000 in damages to rival agent Jason Bernstein for fraudulent conduct in stealing client Kenny Golladay.
Wow, is that finding common?
Highly unusual. These types of disputes between agents, while common, frequently settle out of arbitration. To avoid public findings, maintain industry relationships.
Makes sense.
Furthermore, there had apparently never been a decision finding that an agent violated the regulations in this specific context, client poaching via fraudulent means before.
So what are the implications for France?
Severe. The stage is now set for the NFLPA's Committee on Agent Regulation and Discipline, CART-R, to review the finding. They could very well suspend him, even revoke his certification entirely.
And his career as an NFL agent?
Potentially. It's a real warning shot for agent conduct across the league.
That's a huge finding, a real precedent setter. What's interesting is how different leagues approach agent regulation, right? Not one size fits all.
That's right. The NBA Players Association has a much more limited approach compared to the NFLPA.
Oh, so
It only requires arbitration for disputes directly related to the standard player-agent contract, SPAC, specifically for negotiating NBA player contracts.
So other disputes can go to court.
Other disputes like marketing deals, endorsements, financial management outside the SPAC's scope, those can actually be litigated in court.
Highlights a significant difference in regulatory scope. Provides different avenues for redress depending on the nature of the dispute.
Exactly.
The evolving legal careers in sports are also worth a deep dive, especially for those listening who might be considering this path.
Definitely.
We're seeing more specialized in-house counsel roles. Jill Engels, VP of Legal for the Milwaukee Bucks, talked about the challenges.
High visibility, little room for error, media scrutiny.
Right. But also the immense rewards. Seeing a finished arena project launch. Pride in facilitating Make-A-Wish contracts where kids sign a one-day deal. A unique blend of high-pressure corporate law and community impact.
And her career path highlights the value of prior collegiate athletics experience, internships at NCAA Enforcement, Marquette's GC office, USC Athletic Compliance.
Found that experience transferable.
Highly transferable to the fast-paced, complex world of pro sports. We've also seen strategic hires like Kevin Manera as GC for the Green Bay Packers, brings experience from league and team levels, invaluable for the Packers' unique structure.
And Melissa Robertson's promotion at the Seattle Mariners.
SVP and General Counsel, underscores a focus on organizational compliance, strategic thinking, collaborative approach within an MLB team. Shows how legal leadership is becoming increasingly integral to front office operations.
It's clear the lines between collegiate and pro-legal roles are blurring. Specialized expertise is highly valued across the board.
Absolutely. John Dykema's newly created position at Michigan State is a perfect example.
Executive Senior Associate, AD Student Athlete Management, and Assistant General Counsel.
Right. Leveraging his 15 years with the Detroit Lions to handle the incredibly complex, rapidly evolving areas of NIL, sponsorships, media rights, employee contracts for MSU, essentially building a new legal framework for their athletic department.
And this trend extends to other specialized collegiate roles, reflecting the professionalization of college sports.
For sure. Jim Tanner, former corporate attorney and sports agent, transitioned to associate AD for basketball at UNC men's basketball.
Advising on contracts, transfer portal, program advancement.
His background provides a unique perspective on managing high-profile athletes and their evolving needs. Similarly, Andrew Brandt's role at Louisville Athletics.
Advising on contracts, NIL strategy, agent relations, long-term financial planning.
Another example of how universities are positioning themselves to lead, not follow, in this transforming college sports landscape. Recognizing legal and strategic foresight are crucial.
And in private practice, specialized firms are expanding their sports capabilities.
Seeing that too. Littler, a major labor and employment firm, added Nash, Eisenstein, and Olesen, specific focus on unique labor and employment challenges in the sports industry.
Plus new firms launching.
A prominent plaintiff's attorney specializing in Title IX matters launched a new law firm, emphasizing continued focused advocacy for gender equity in college athletics. These developments signal growing, diverse demand for sports law expertise across various specializations. These moves clearly show the growing demand beyond just traditional contract law. Another fascinating niche, according to insights from Carmichael, is brand management and intellectual property.
What does that involve?
Handling advertising, media, entertainment, IP matters for clients like leagues, athletes, manufacturers, merchandising companies.
So contract negotiations.
IP clearance.
Intricate contract and rights negotiations, ensuring IP clearance for team league indicia, managing trademarks, navigating publicity rights, developing athlete branding strategies, structuring complex revenue-sharing arrangements.
It's a space where deep IP understanding meets sharp sports business savvy.
For those looking to get into sports law, Josh Gordon offered some truly great general career advice.
Yeah, really practical stuff.
Emphasized foundational areas: athlete sponsorship marketing agreements, sports agent regulation, and of course, college athletics, NIL. Sounds like a solid starting point.
He also highlighted the immense importance of mentorship, citing his own experiences with Marquette law professors, NCAA staff guiding his early career,
and general advice.
Reinforces that strong contract drafting skills remain foundational. Truly understanding the client's mindset, athlete, team, league is crucial. Staying open to new opportunities while actively building relationships across the interconnected sports world is key.
Anything to avoid.
He wisely warned against overly aggressive deal-making, advocating instead for a collaborative approach built on trust and integrity. Emphasizing the sports world is smaller than you think, reputation travels fast.
Good advice. Okay, when disputes inevitably arise, new resolution mechanisms are emerging, aiming for more efficient, specialized solutions than traditional courts.
Definitely needed. For collegiate athletics, we're seeing fair sports, the form of arbitration and independent resolutions.
Pitched as a new and neutral place to resolve legal disputes in college sports, modeled on the CAS system in Europe.
Exactly. Fair sports aims to foster and promote independent dispute resolution amongst college sports stakeholders for issues like scholarships, collective agreements, NIL deals, agent contracts.
And the CAS model it emulates is known for speed, confidentiality.
Speed, confidentiality, subject matter expertise. This industry-specific approach is designed to offer a more tailored, efficient resolution process than traditional litigation, where judges might lack specific sports industry knowledge and the public nature can be damaging.
Promises quicker, more private resolution. Makes sense.
Esports, too, developing its own specialized dispute systems. Crucial given the global nature and rapid growth.
Lack of a universal governing body leads to varying standards, right?
Right now, yes. But systems like IGT, the International Gaming and Esports Tribunal, and Riot Games' DRM, their dispute resolution mechanism, are emerging to fill that void.
How do they work?
They merge a robust legal process with deep understanding of the competitive gaming landscape, addressing shortcomings of traditional legal systems: slow pace, lack of flexibility for rapidly evolving issues, lack of subject matter fluency among judges unfamiliar with esports' unique ecosystem.
Goal is to build trust, reduce ambiguity.
Establish trust, reduce ambiguity in rules and enforcement, promote industry sustainability in this rapidly growing global industry where disputes often involve international players, teams, virtual assets.
Okay, one of the biggest shifts impacting both college and pro sports, with huge legal implications. The massive expansion of sports gambling.
Huge impact since Murphy v. NCAA.
Seeing rising addiction concerns already. Data shows record levels of gambling addiction help-seeking, paralleling the explosive growth of sportsbooks.
What are the numbers?
Cumulative national increase of 23% in helpline calls since Murphy. Significant state-level increases. Ohio plus 67%, Massachusetts plus 47%.
Wow, that's a major public health concern the legal system is grappling with. Raises questions about institutional responsibility.
And the NCAA's stance. Controversially shifted, hasn't it?
Yeah, evidenced by its deal with Genius Sports to sell data to the gambling industry.
After years of fighting against legalized sports betting, citing integrity, athlete well-being.
Complete reversal, as Dr. Levant, an expert in this area, predicts. Next, we'll see enormous deals negotiated by the NCAA conferences to sell even more data to the gambling industry.
What was his take on the NCAA's move?
He added, quite critically, The NCAA decided it would join the gambling industry rather than fight it, calling for a comprehensive public health response at federal and state levels to mitigate the growing societal harms of widespread sports gambling addiction.
Heavy stuff. Fan conduct, public order, team responsibility. Also areas where sports law is constantly tested.
Always evolving.
Saw that recent high school wrestling match brawl in New Jersey involving top wrestler Anthony Knox Jr. and his father.
Yeah, made headlines.
The court actually intervened with an injunction, a court order, finding that violating fundamental fairness provides irreparable harm.
So the disruption itself was irreparable harm.
Right. Emphasizing the importance of high school sports and fair process, meaning the court recognized that disruption to fair play and potential damage to the sport's integrity for these young athletes was so significant, money alone couldn't fix it.
And internationally, we see more proactive legal measures against fan violence.
The UK, for example, uses football banning orders, FDOs, under the Football Spectators Act, 1989.
Prevents known troublemakers from attending matches.
Exactly. Can even require them to surrender passports before international tournaments like Euro 2024, preventing travel abroad to cause trouble. Showcases proactive legal measures against hooliganism.
Interesting contrast. And in the NHL, the culture around fighting.
Unique legal dynamic there. The league's culture kind of internalizes on-ice fighting as not violent in the same way stick assaults are, despite the physical impact.
And courts stay out of it.
Courts have largely been reluctant to intervene in the league's internal governance on this specific issue, deferring to the league's unique rules and culture. Fascinating example of judicial restraint. Finally, the legal perils for medical professionals in sports. Immense. Evidenced by a recent MLS medical malpractice verdict highlighting the perils of being a team doctor, underscores the high stakes when player health is on the line.
This is further compounded by what many experts call a structural conflict of interest in many major American sports leagues.
How so?
Often, team sponsorships with healthcare organizations dictate the selection of team doctors rather than decisions being based solely on independent medical assessments.
Raises concerns about player welfare.
Significant concerns. Potential for subtle pressure on team doctors to prioritize the team's needs, getting a star player back quickly over the athlete's long-term health, especially when their employment is tied to the team or its corporate partners.
And looking beyond the immediate sports field, whistleblower cases. Also making headlines in the broader sports entertainment industry, like the lawsuit against Icon Park.
The Orlando freefall ride incident.
Yes, by a former employee, alleging incredibly serious issues.
What kind of issues?
Modified sensors to exceed safety limits, insecure seats, structural cracks, lack of proper training for operators, all allegedly contributing to that tragic incident.
And the defense
Claims these new allegations conflict with the employee's prior statements, setting up a complex legal battle around employer responsibility and whistleblower credibility.
Yeah.
Very public, emotional, legal fight. Touches on the fundamental duty of care. Wow, what a deep dive into legal complexities underpinning the entire sports ecosystem. Grassroots to global stage.
It really covers everything.
It's absolutely clear sports law is far from static, a field in constant motion demanding agility and foresight from legal professionals.
Indeed. From player rights and team finances to ethical considerations, burgeoning career paths, sports law is a dynamic field demanding constant attention, critical thinking, adaptability.
Yeah.
The changes we've discussed today, just snapshots of a much larger ongoing evolution, pushing the boundaries of traditional legal practice.
We've really seen how NIL and the transfer portal are rewriting the rules of college athletics in real time.
Completely transforming it.
How fundamental questions of identity and equity are shaping deeply personal legal battles. The astronomical stakes in pro-team operations and IP.
Billions on the line.
And the diverse, exciting ways lawyers are engaging with this field. In-house counsel, specialized private practices.
This constantly evolving landscape is a testament to how deeply intertwined law is with every aspect of our sporting lives.
For sure.
It's not just about regulating existing structures, it's about shaping the future of competition and entertainment. Requires legal pros to be agile, forward-thinking, ready for whatever curveballs the sports world throws next.
So, considering how quickly technology, player power, global money are reshaping sports, what do you think will be the next major legal frontier to emerge? Something we haven't even conceived of yet.
That's a great question.
What's the biggest legal challenge sports will face in the next 5 years? We'd love to hear your thoughts.